Good morning. Can everyone hear me okay?
I can hear you.
Okay, looks like we got quite a few people joining. Let me get everybody in. Okay, let me get everyone to just kind of give me an announcement of who you are and what your role is in this particular case, who you may represent. We'll start out in my top left, which is I show Kelly Casey. Miss Casey, are you there?
Yes, sir. Good morning.
Good morning. How are you?
I'm well, thank you. I'm here with the lender, Primal Land Capital and Good Floor Loans.
Okay, are you an attorney?
No, sir.
Okay. And Ms. Strom, is that, I pronounce it correctly? Is it Strom? Can you hear me? Okay, we'll go to Mr. Spector. Mr. Spector, I think you're the defendant in this case, is that correct?
No, Judge, I'm the proposed receiver.
Oh, I'm sorry. Yeah, I did see your name. I'm sorry.
Okay.
Okay, Ms. Sanchez.
Good morning, Your Honor.
Good morning. How are
I'm
you?
with K&L Gates, and I represent Good Floor Loans along with my colleagues Victoria Agontoya and Greg Lewis. And Ms. Agontoya will take the lead on this.
Okay, so you and Miss, is it Aguntora?
It's Oguntoye.
Oguntoye, okay. Forgive me if I mispronounce it as we move forward, but you feel free to correct me as we go along. So Miss Oguntoye, you're gonna present this application, is that correct?
That is correct, Your Honor.
And you're also,
We
represent the
also
plaintiff,
we
Mr.
represent the plaintiff, Your Honor, and
Mr. Lewis as well, right?
correct, Your Honor. Well, all three of us are with K&L Gates.
Okay, very good.
I believe the S Rum person is the court reporter, Your Honor.
Okay. Now,
You're
right.
muted, ma'am. We cannot hear you.
You need to unmute, we can't hear you. Maybe she wants to stay muted. Can you hear us okay? I'm gonna just send her a little chat, maybe she can unmute herself.
There we go. Can you hear me now?
I
Yes.
can hear you now,
Okay.
very good. Okay,
Now I missed Kelly Cassie. Who does she represent?
she's with the lender, she's not an attorney, she's just, she represents the
Lender.
plaintiff. She's
Okay.
with the plaintiff, which is fine. Okay, what about notice to the defendant? Give me a status on the local rules require that we usually give opposing parties a 2-hour notice of any pending hearing, require
Yes.
any TROs or requests of this nature. Can you give me a status of that, please?
Yes, Your Honor. We provided notice to the defendant yesterday afternoon, actually. We sent an email to the president of Lone Star, the defendant in this case, Mr. Robert Morales is his name. And so we sent him an email yesterday afternoon. We provided a copy of the verified petition, a copy of the notice of hearing, and the court coordinator, Mr. Nicholas Zargoza, I believe is his last name, he also provided information to Mr. Robert Morales with the Zoom information for the hearing today as well. And that was done early afternoon yesterday, Your Honor.
Okay. All right, fine. Now, I did go through before you make your presentation, I did go through the application, and it appears that there's been an agreement to have Mr. Spector serve as the receiver if the court appoints one today. Is that correct?
Well, there's not an agreement for Mr. Spector specifically, but there's an agreement that the lender does have, upon a default, the lender does have the remedy of a receiver under the loan agreement.
Okay. Okay, maybe I misunderstood whatever it is. Okay, let's move forward. Well, one other question before we move forward. What's the status of the bankruptcy? Has the stay been lifted? Can you give me an update on that?
Yes, Your Honor. So the bankruptcy is no longer, the stay has been lifted, the bankruptcy's been dismissed, and a amended plan of reorganization had been entered, which is what the defendant was operating under and which is what he defaulted under.
Okay. Do you have any, I didn't see in that in your pleading, do you have anything in your pleading regarding the dismissal of the bankruptcy?
We do not, but we certainly could submit that to you, Your Honor.
Yeah, I'm gonna need that. As you know, looks like you've gone and crossed all your Ts, but until we know that the bankruptcy is no longer involved with this particular matter, our hands are kind of tied. Do you have that readily available? I could get that to me today?
Yes, Your Honor. Mr. Greg Lewis will pull that information up and will provide that probably before this hearing concludes here.
All right, very good. Okay, with that having been said, I think the court reporter has a listing of all the parties who are on this call. And with that, you may proceed.
Thank you, Your Honor.
Are we on the record now?
Yes, let's go on the record. Let me call this case. This is DC 2301431. It's a case that's, give me a few seconds here. It's a case that's styled Good Floor Loans LLC versus LS Motor Cars LLC. And we're here on an application to appoint a receivership and for some temporary injunctive relief. All right, you may proceed.
Thank you, Your Honor. May it please the court, my name is Victoria Guntoye from the Dallas office of K&L Gates. And I'm here representing the plaintiff Good Floor Loans LLC. By way of brief background, in 2019, plaintiff agreed to lend to defendant up to $1 million floor plan credit facility to finance defendant's floor plan inventory. We attached a copy of that loan and security agreement as Exhibit A to the verified petition. Under that agreement, defendant granted a first priority lien and security interest in several categories of collateral. Most importantly is all present and after acquired inventory, including all of the motor vehicles and supporting receivables to secure the repayment of the loan. Plaintiff perfected its lien on the collateral or recorded its UCC financing.
I'm sorry, plaintiff what?
Perfected its lien on the collateral by recording a UCC statement as amended, naming the defendant as the debtor and plaintiff as the secured party. And we attached those documents to the verified petition as exhibits E, F, and G. There are a few reasons why we're seeking appointment of a receiver and a temporary injunction here today, about 5 reasons specifically. The first reason is because defendant has stopped paying, right? We've had some payment defaults. So very soon after executing the loan documents, defendant defaulted, eventually sought protection under Chapter 11 of the Bankruptcy Code, as Your Honor mentioned earlier, which led to the confirmation of a reorganization plan back in August of 2021. That plan set out defendant's repayment obligations under a new schedule. It also contained some additional requirements, including setting forth what specific actions would constitute an event of default, in addition to non-payment, of course. Unfortunately, defendant did not comply with the bankruptcy plan. Some things that it didn't maintain an account control agreement as required. It didn't maintain an intercreditor agreement. It didn't allow plaintiff to have view access on all of its designated accounts as required under the bankruptcy plan. But most importantly was that defendant, they made some initial payments, but then didn't make the 12-month interim lump sum payment that was due back in September of 22, didn't make 2 monthly payments of $9,000 that were due in December of 22 and January of 23. On January 10th of 23, plaintiff sent a written notice to defendant, of the payment defaults. We attached a copy of that notice as Exhibit K. Defendant has not cured the payment default. No payments have been made. The second reason is defendant's failure to turn over the certificates of title for the inventory. So under the amended plan, once a payment default had occurred, just as it is done here, defendant was required to turn over the certificates of title in its possession by January 20th, 2023. It didn't do so. The third and fourth reasons why we're seeking receivership and a temporary injunction here today is defendant has confirmed that it is presently insolvent, it cannot meet its payment obligations, and that other lenders have security interest in existing inventory in violation of the loan documents. So on January 12th, Mr. Morales, defendant's president, contacted plaintiff. He explained that even though plaintiff had a first priority security lien on all of its receivables, that defendant had contracted with an entity called Agora Data, and Agora took possession and title of all of defendant's receivables in exchange for capital funding. As of that date of the call of January 12th, Agora had advanced no payments, but was collecting directly on defendant's receivables in violation of the loan documents. Mr. Morales stated that he could not collect on any receivables, he could not originate any new consumer loans to generate additional income. So notwithstanding plaintiff's first priority senior lien on all inventory, Mr. Morales has stated that another lender secures the existing vehicle inventory. Plaintiff has confirmed through its view access on at least one of defendant's bank accounts that as of January 23rd, defendant's bank account had a negative balance of $14.83, negative. So the fifth and final reason why we're seeking the request that we're seeking here today is that from all accounts, it appears that defendant is now trying to dissolve the business and start up another business at the same location. So every Friday, plaintiff has an auditor that goes by defendant's business to perform an audit. On January 27th, the auditor discovered that the name of the business had changed from LS Motors LLC to North Texas Auto Hub LLC. We attached a copy of the certificate of formation for that entity as Exhibit L to the verified petition. The certificate of formation shows that that company is owned by Mr. Morales' son, Roby Morales. As of January 30th, defendant owes plaintiff in excess of $467,178.23, together with accrued and unpaid interest, attorney fees, and all other unpaid fees and reimbursable expenses provided under the loan documents. So we're here seeking two forms of relief from this court: appointment of a receiver and a temporary restraining order. With respect to the appointment of the receiver, we're asking the court to appoint a receiver over the collateral, to take possession and control of the collateral, operate the business in accordance with the receivership order that we'll submit to this court for entry. And the receiver's job will be to take control of defendant's assets to the extent that such assets are subject to the liens of plaintiff and our collateral, and protect plaintiff's interest in the collateral. There's three specific authorities for this court's appointment. Section 64.001 of the Texas Civil Practice and Remedies Code authorizes the appointment of a receiver in an action by a creditor to subject any property to his claim. So for a secured creditor, just like the plaintiff here, Section 64.001 allows this court to appoint a receiver. Also, this court does have equitable powers to appoint a receiver. And defendant, and this is the most important here, defendant specifically agreed to this relief in the event of a default under Section 14B of the Loan and Security Agreement. Defendant agreed that under these circumstances, that plaintiff could seek an appointment of a receiver from the court. Under Texas law, for the court to appoint a receiver, plaintiff has to show just that it has an interest in the property and the property is in danger of being lost, removed, or materially injured. As we've discussed, plaintiff does have an interest in the collateral as evidenced by its UCC filings. And most critically, the collateral is in danger of being lost, removed, or materially injured. And so those are the key issues there. Defendant has this entity, Agora, that's collecting all of its receivables. It's not able to, generate new loans. It's not able to meet up with its debt obligations. And it does look like the business is in jeopardy by reason of the fact that there's a new sign at the business location. So it is critically important that we have a receiver go in and ascertain what's going on here and determine what's the status of the collateral and protect plaintiff's interest in that collateral. Only a receiver can protect the collateral in these instances and can protect plaintiff's interest in the collateral and see if there's any chance of obtaining any receivables that could be generated or that are being generated from that collateral. If an appointment of a receiver is not done here, plaintiff will suffer irreparable harm since the collateral is literally the only known and available and realistic source of repayment of the debt obligation that's owed in this case. And also because defendant's actions of assigning the collateral to third parties essentially amounts to disposing of that collateral. There's a real risk here that if a receiver is not appointed in this case, that there's not going to be any collateral at all to satisfy this debt. Plaintiff requests that Mr. Howard Mark Spector, who's an attorney at Spector and Cox PLLC and has the necessary qualifications, is not an attorney for any party, not related to the plaintiff or the defendant. So it's a neutral third party, and he's fully qualified. We submitted his resume as Exhibit M to the verified petition. We asked that Mr. Howard Spector be appointed immediately as a receiver and continue as a receiver through the time of trial or other disposition of this case. We also respectfully request that the plaintiff's bond for entry of the order appointing a receiver be set to no more than $500 due to defendant's consent to the relief requested, the substantial risk to plaintiff's collateral in the absence of an appointment of a receiver, and the comparative insignificant harm to defendant from the entry of such order. We also respectfully request that the receiver's bond to secure the receiver's obligation under the order appointing the receiver similarly be set to no more than $500 due to defendant's consent to the relief requested, the substantial risk in the absence of an appointment, and the insignificant harm to defendant from the entry of such order. With respect to the application for the temporary injunction, we're asking that the court enter a temporary injunction immediately to prevent the sale, transfer, or any other disposition of all of the assets of defendant to the extent that such assets are subject to the liens of plaintiff and constitute collateral to protect plaintiff's interest in the collateral. Chapter 65 of the Texas Civil Practice and Remedies Code and Rule 680 of the Texas Rules of Civil Procedure authorizes this court to issue a temporary injunction if plaintiff shows that it has asserted a viable cause of action against the defendant, has a probable right to relief that it seeks, and will suffer probable, imminent, and irreparable injury without the entry of a temporary injunction, for which there's no adequate remedy at law. The court also has to consider the balance of hardships to the parties if it doesn't enter this relief that's being sought. As to these elements, plaintiff has stated a viable cause of action against defendant for breach of contract and will in all probability prevail on that claim, given the fact that defendant has breached its obligations, has stopped making payments, has encumbered the collateral in ways that violate the loan documents, and essentially has indicated that it's looking to close down the business. As explained earlier, there's a grave and immediate risk of further diminution or probable complete loss of the collateral in the absence of a temporary injunction. So we're asking this court to enter temporary injunction to preserve the status quo pending final trial or other disposition of this case and prevent defendant's sale, transfer, or further encumbrance of the collateral, except as authorized by this court. If this court doesn't enter the temporary injunction, defendant, which has been in default of its obligations for months, has refused plaintiff's demands for payment, has refused to cure its default, may sell, transfer, or dispose of the collateral, or even worse, just shut down and disappear. Plaintiff really fears that due to defendant's continued inability to meet its obligations, defendant cannot satisfy any of its obligations here. Plaintiff has no other remedy at law, no adequate remedy at law. Injunctive relief is really the only appropriate remedy to preserve the status quo and to prevent loss or dissipation of the collateral. Compared to the risk to plaintiff's collateral, absent the entry of a temporary injunction, the potential harm to defendant is de minimis. Under the loan agreement and the other loan documents, defendant has agreed that if it defaults under these circumstances, that plaintiff has the right to injunctive relief. So defendant cannot be injured from plaintiff's enforcement of defendant's own agreements regarding the relief of a temporary injunction. Similar to the request for the appointment of a receiver, plaintiff respectfully requests that the bond for entry of a temporary injunction be set at an amount not to exceed $500 due to the risk to plaintiff's collateral absent the entry of a temporary injunction.
I'm sorry, you're a little bit garbled. Due to the risk of what?
The risk to plaintiff's collateral absent the entry of a temporary injunction and the insignificant harm to defendant from the entry of such order and restraints. That's all I have, Your Honor, and I'm happy to answer any questions that you might have.
Well, thank you. You've been very thorough. The court having heard testimony.
I'm sorry, Your Honor, it's difficult to hear you.
Can you hear me better now?
A little better.
Wow. Okay, let me check with my volume here. How is that?
It seemed to be a little better.
Just a little better? Let me see here. How is that?
Seems to be a little better. Let's try it now.
How is that?
I can hear the court perfectly fine.
Okay, well, but she needs to hear me for the court record. How is that? Is that better?
That's a little better.
Okay, I'll have to get a tech down here to find out what's going on later. But well, thank you very much. The court having heard testimony or argument and having reviewed pleadings, the court is of the opinion that there is a possibility for irreparable harm to the plaintiff, and the court will enter a temporary restraining order and will appoint a receiver. The court will set those bonds at $500 for each. Regarding the receiver, unfortunately, many of the courts have their own list of vetted receivers. I'd have to check with Judge Redmond to see what her preference is. I appreciate Mr. Spector being available to serve in this capacity, and if she so decides to use him, then I will include that in the order. I did not see an order in the file. Have you submitted an order?
Your Honor, we're happy to submit the order right at the conclusion of this hearing.
Okay.
If you let us know your preference on how you want that submitted, if you want us to file that with the clerk or send that via email as a Word document, we'll obtain your preference and submit it that way.
Send it in a Word format and send it to ronald.hurdle@dallascourts.org. and include the language that you'd like to have in the TRO. And of course, as you know, it should include provisions for a hearing in 14 days to determine if this TRO is going to continue into a temporary injunction. That should be set on Tuesday, February the 21st. And let's schedule it for 2:00 p.m. Make sure that the opposing counsel or the opposing party gets notice of the hearing. Obviously, you know, you have to come down and you have to physically post the bond before the TRO becomes effective. And if you will mind leaving blank the appointment of the name of the receiver, I will speak with Judge Redmond. And if she so agrees, then we will appoint Mr. Spector per your request. Anything further?
Yes, Your Honor. So I do have the final decree for the bankruptcy here. I can share my screen and show that to the court, or I can email it to you. What is your preference?
Email me a copy of that, and you probably should file that with the court as well.
We will.
Obviously, that gives this court some jurisdiction. Without that, we're kind of limited in what we can do.
Understood, Your Honor. Thank you.
Anything further? Mr. Spector, thank you for joining us, and we'll be back in touch with you. And once I speak with Judge Redmond regarding her vetted list, and if she decides to appoint you, then we will include you in that order.
Thank you, Judge. I've served for Judge Redmond before,
Okay, very good.
so I'll just wait for it.
All right. All right, anything further?
Nothing, Your Honor.
Okay, see if you can get that order to me this morning, okay?
We will. We'll have that within the hour.
If there's nothing further, everyone, you may be dismissed. Thank you very much. Have a good day.
Thank you, Your Honor.